We would like to extend a very special thank you to our friends over at Alley Moss, Rogers & Lindsay, PA, for their continued support of Yacht Sales the Law. This 25th edition wouldn't be possible without their generous endorsement over the years.
Maritime arbitration has been around for hundreds of years. Now we have a new forum to solve our disputes. The IYBA has created the International Yacht Arbitration Council to solve our disagreements. We have experienced maritime attorneys and yacht brokers to serve on our panels, people who know the law, who know boats, and who know the yacht business. IYAC arbitration can handle yacht claims, contract, purchase, and commission disputes privately, quickly, and less costly than going to court. Sometimes disputes happen, and when they do, the IYAC is here to help you solve them.
IYBA would like to thank Yacht World for their support of this year's 25th Annual Yacht Sales the Law. IYBA would like to thank Howard S. Reeder, Inc. for their support of this year's 25th Annual Yacht Sales the Law.
Do you want to generate leads? Is free your favorite price? Then you need to check out IYBA.pro. IYBA.pro is your industry-owned platform for all listings and marketing. Create robust yacht sales and charter profiles, elegant marketing material, have access to all your exclusive data, and enjoy premium search engine optimization by signing up with us. For more information on how to join IYBA.pro, call the IYBA headquarters or email me at casey@iyba.org.
We would like to extend a very special thank you to our friends over at Alley Moss, Rogers & Lindsay, PA, for their continued support of Yacht Sales the Law. This 25th edition wouldn't be possible without their generous endorsement over the years.
Maritime arbitration has been around for hundreds of years. Now we have a new forum to solve our disputes. The IYBA has created the International Yacht Arbitration Council to solve our disagreements. We have experienced maritime attorneys and yacht brokers to serve on our panels, people who know the law, who know boats, and who know the yacht business. IYAC arbitration can handle yacht claims, contract, purchase, and commission disputes privately, quickly, and less costly than going to court. Sometimes disputes happen, and when they do, the IYAC is here to help you solve them.
IYBA would like to thank Yacht World for their support of this year's 25th Annual Yacht Sales the Law. IYBA would like to thank Howard S. Reeder, Inc. for their support of this year's 25th Annual Yacht Sales the Law.
Do you want to generate leads? Is free your favorite price? Then you need to check out IYBA.pro. IYBA.pro is your industry-owned platform for all listings and marketing. Create robust yacht sales and charter profiles, elegant marketing material, have access to all your exclusive data, and enjoy premium search engine optimization by signing up with us. For more information on how to join IYBA.pro, call the IYBA headquarters or email me at casey@iyba.org.
We would like to extend a very special thank you to our friends over at Alley Moss, Rogers and Lindsay, PA, for their continued support of Yacht Sales the Law. This 25th edition wouldn't be possible without their generous endorsement over the years.
Hello, and welcome back to Day 2 of Yacht Sales the Law. I'm Paul Flannery, Executive Director of the International Yacht Brokers Association. Yacht Sales the Law 2020 is brought to you by Alley Moss Rogers Lindsay, Lauderdale Marine Center, Yacht World, and the folks at Howard S. Reeder Incorporated Customs Brokers. Our space has been provided by Pier 66, and we're connected remotely through JV connectivity. Yesterday, we met Bubba Calhoun and Bill Boatwise, the protagonists to our story As the Prop Turns. We began with a bit of a rocky road as Bubba's learning what it's like to be a yacht broker. David Moss provided great commentary and moderation to our expert panels. Let's see how it's going to go as we go into Act 5 of As the Prop Turns.
Our internet connection today is brought to you by the team at JV Connectivity, Super Yacht Cellular Data.
Do you want to generate leads? Is free your favorite price? Then you need to check out IYBA.pro. IYBA.pro is your industry-owned platform for all listings and marketing. Create robust yacht sales and charter profiles, elegant marketing material, have access to all your exclusive data, and enjoy premium search engine optimization by signing up with us. For more information on how to join IYBA.pro, call the IYBA headquarters or email me at casey@iyba.org.
Damn haircut one of these days, I can't forget. Yeah, baby.
Bill Boatwise.
Yeah, hey, Bill. Hi, it's Bubba.
Hey, how you doing, Bubba?
Bubba, look here. I just stopped to get me some lunch. I needed to call you real quick. Look, I'm having a problem. I just talked to Chad a few minutes ago. We can't get no insurance on the boat.
No insurance, huh? No, tell me why.
Something about some tropical storm or what the heck's, what's insurance for anyway? I just don't understand some of this stuff.
Yeah, I'm looking here, and we do have Tropical Storm Omega coming our way, and we are in the going concern, and the way the insurance markets work is that they will not bind insurance if we are in the cone of concern for a named storm.
Well, what about them deposits? You told me if people don't meet the dates that they start losing deposits and stuff. I don't want to put nobody in no trouble. I mean, sure don't want to take Chad's money from him.
So there's a stipulation in the contract for force majeure that if we are in the cone of concern of a named storm, we can delay the dates to no penalty of the seller or the buyer, and then we can close once the storm is passed. And so basically we're just going to have to delay everything until this named storm gets beyond us.
Well, what about them? What about all them dates you was talking about? Because And deposits, I sure can't lose no deposits. What if I can't take Chad's money from him? What are we gonna do?
Yeah. So the buyer's deposit is not going to be in question. You don't have to worry about that. The contract lays that out. In the meantime, until we do close and Chad can get the boat insured, the seller, my client, will maintain the insurance. So if there is some damage from the storm, that'll be on our end and the seller's responsibility to address.
Huh. Okay.
So Bubba, what I would do is go ahead and structure an amendment that extends the dates of the contract, and then get everybody to sign it off on it, and then we can continue to stay within contract and move forward and wait for the storm to pass us by.
All right.
Well, thanks, Bubba. Let's keep pushing forward here.
All right.
All right. Okay. Here we go. Let's make the call. Mr. Ficarino. Bill Boatweiss here, sir. Hey, listen. Well, as much as I'd like to have good news for you, I don't today. We're going to have a little bit of delay in our closing. We have Tropical Storm Omega is bearing down on us. We are in the cone of concern. Well, the buyer cannot bind insurance on the boat because we are in the cone of concern on a named storm. So we are going to have to delay things. Yeah, I understand, Mr. Ficarino, but the reality is that he can't insure the boat until this storm has come and gone. No, sir, that's where we can't take his deposit, because the contract clearly stipulates in a force majeure situation or an act of God, the buyer has the opportunity to extend out the dates of the contract and wait till the storm passes and then close. So yeah, you're forced to extend the dates. The contract clearly stipulates that he has the ability to do this. So I understand that this is not what you want to hear at the moment, but it's what you need to hear, and there's nothing we can do. Well, you can always run everything by legal, Mr. Ficarino, but he's going to tell you the same thing I'm telling you right now. Well, I think we'll probably have to delay it out a week or two, depending on how long this storm takes to get through. But nonetheless, you will remain as the insured on the boat as we prepare for the storm. And as soon as it's passed, the buyer will be able to bind and we'll be able to close. But we're not going to... Mr. Ficarino, we've been through a survey on the boat. We're waiting to close on this boat. It has the storm out there. That would be a horrible idea. I don't think you can even legally do that, take the boat out and use it with your family. Just let it sit, hang tight. We're going to get through this. I understand we're delayed, but we'll get through it. Just hang tight. Don't do anything. Just sit back and relax. And as soon as we can get beyond this storm, we'll close on the boat and it'll be over with. Well, let's hope that doesn't have to happen, Mr. Ficarino. Yeah, well, again, this is nobody's fault, but this is the way it's going to happen. This is what the contract states. This is what protects us in the contract. So this is how it's going to happen, Mr. Ficarino. All right? Will do, sir.
And then for a time tomorrow night and Thursday, we may see tropical storm force winds, mainly along our coast, running 40, 50, 60 miles an hour. Yeah, I think so. A product of us being kind of on the wrong side, the east side of storms.
Welcome back to day 2 of Yacht Sales and the Law. I'm David Moss with Ali Moss, Rogers and Lindsay. I am joined for this panel by my dad, Rob Moss, also of Ali Moss, Rogers and Lindsay, and Michael Karcher, fellow maritime attorney. We're going to be talking about some of the issues that were raised in Act 5, which we just saw, specifically the issues around force majeure and the incoming storm and arbitration as a means of dispute resolution. So first off, I want to start by asking you, Dad, what did you think about the force majeure claim that they were asserting in Act 5?
Well, I thought it was questionable, but also I think you need a little bit more background to know what the correct answer is. And what I mean by that is that typically in a force majeure clause, you're talking about events that prevent one party or the other from performing their obligations under the contract. And there's no obligation or right to be able to obtain insurance under the terms of most of the agreements that we work with. So the mere fact that you couldn't get coverage because of a named storm does not mean that that's a force majeure event that precludes, or I'm sorry, that justifies your not closing. On the other hand, if it was an event or a named storm which would jeopardize the delivery, that's a different issue.
So the failure to bind insurance alone wouldn't be enough, but it's possible that the same event would prevent them from transferring possession of the vessel, and that would give rise to a claim for force majeure.
Yes.
Now,
but let me say this too, David. Force majeure is not a general legal principle, meaning it's not something that's part of our common law. It's something which is contractual in nature, meaning a force majeure event is what the contract says is a force majeure event. So if the contract said, for example, the inability to obtain insurance would be considered a force majeure event, then it is a force majeure event. But if the contract is just more general and says that it's an event which prevents one part or the other from performing their obligations, which is a common statement of the principle, then I don't think that it would be considered force majeure.
Mike, what do you think? Do you think there's an argument for force majeure?
Well, I think so. Whenever you get two lawyers, you probably get three opinions. Right. But in this case, force majeure is, as Rob says, contractual. It did arise out of a common law, English common law tradition, and it mostly for frustration of the contract, and it has kind of worked its way now. It's what's in the contract. So the first thing to look at is go to the contract. Is a hurricane, failure to get insurance, failure to delivery? It's usually, as Rob says, something where this did not happen. The boat was not delivered in time. Charter contracts where the boat did not make it to the location because there was a storm. But you might look at it as a general, because of the hurricane, we could not close, and getting insurance is certainly part of it. Does it absolutely cut it off? No. Is it something that may look it into a delay? Probably, and hopefully they could work it out. But in and of itself, it's not a force majeure, therefore no closing.
I think a lot of non-lawyers tend to focus on the event itself. Is the event something that would count as force majeure, like a storm or
COVID-19? I mean, we've had a lot this year about whether COVID-19 is a force majeure event. But that, to some extent, begs the question. If you have a broad force majeure clause in your contract, then yeah, it probably would constitute a force majeure event. But you then have to look at what effect the event has. If you can still perform, notwithstanding COVID-19, then it doesn't justify not performing.
And COVID-19 in and of itself may not be a quote-unquote force majeure, but because of COVID-19, I cannot get into the country.
Right, it's the restrictions that arise from
that come out of the event.
That's right.
And so the COVID-19/force majeure, reason may be, and they didn't let me into the country. That's the out of control or outside of our control force majeure event.
Absolutely.
I've seen some contracts where the force majeure clause consisted solely of a definition of force majeure events and said nothing about excuse or the effect that had on performance. And at that point, I don't know how a court's supposed to interpret that.
Well, I think clearly the parties intended the occurrence of one of those events to justify a delay in performance. I mean, I think you can imply that infer that, from the fact that it's there. But that is not careful drafting, let's put it that way.
We've been talking about what's in the contract, but Mike also mentioned frustration as something that doesn't have to be in the contract. Can you talk a bit about the difference between frustration and force majeure?
Well, frustration is part of our common law, and it doesn't have to be in the contract, meaning it's a general legal principle that simply applies. And if an event occurs which prevents the parties from, one of the other parties from performing, then that can result in frustration, which is, I guess, similar to force majeure, but
Typically a higher standard.
higher standard. You're right. It's a higher standard, and it doesn't have to be part of the contract itself. And we were dealing with that issue, the concept of frustration, quite a bit this year with cancellation of charters that were under the MEBA form charter agreements. Because under the MEBA form, force majeure runs only in favor of the owner. Although I think, wasn't it, there was if the charter is unable to return the boat at the end of the charter due to some force majeure event, it applied there, but it didn't apply generally to the charter's ability to perform under the contract. And the concept of frustration then was used, or at least offered, in those situations to justify the charter's failure to perform.
You saw it in examples where the force majeure clause was if the boat could not be there at the beginning of the charter, but it did not apply to that same frustration where the charterers could not fly from New York to the Bahamas and such, and it only ran one way because it was their contract.
I was talking to an English lawyer about this, and he pointed out that under the MEBA contract, the charterer has no obligation to actually turn up. His only obligation is to pay charter hire. So if he was prevented by force majeure from going to the place of delivery, he hasn't been prevented from performing an obligation.
I heard the same. Maybe it was from you talking about this English lawyer, but I don't buy that.
Yeah, that seems pretty.
I mean, the party's intent is not simply to have a boat available, or have the boat sitting in a location. It's to be able to use the boat for the intended purpose of the charter. And if you can't get to the boat, to me, that's frustration.
So when you have a force majeure clause in the contract, typically what does that look like? You have a definition of events that count as force majeure, and it's usually not an exhaustive definition. There's a general term.
Sometimes it is, and that's the problem. I mean, there are agreements which say force majeure means one of the following and blah, 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 blah. And if that's what it says, then you've got to be able to, whatever the event is that you're asserting as force majeure, you have to be able to fit it in with one of those boxes. But more often you see clauses which say that force majeure event is any event that prevents, or unforeseeable event which prevents one party or the other from performing their obligations under the contract, including but not limited to, and then you have your list. And then the list is not exhaustive, and you can rely on the general language at the beginning of the paragraph.
So look for that in these events, but not limited to.
Right.
Or some language to that to leave it a little bit more open-ended as opposed to a short list.
And that saved a lot of people in the sense that there were plenty of contracts out there that didn't refer to pandemics. Some did, but probably more didn't.
Most didn't.
Yeah,
they do now.
Without that, absolutely. But without that kind of general savings language at the beginning, then they would have been out of luck.
It's almost like the insurance policy and all risk policy versus a named perils. If it's not on this list, it's not covered, as opposed to all things.
Right, which is a topic for another day.
Yes.
And in addition to the definition, you typically see what else? I mean, you have a definition of events, and then what else does the clause say?
What it should, you have a definition of events, and then it should describe if one of those events occurs, what happens. And you have to remember that force majeure typically doesn't give someone an out under the contract. It gives them the right to delay their performance until the force majeure event has passed and they can perform. And sometimes in some contracts, there's a limit on the number of days that the parties have to wait for the force majeure event to clear. And if it doesn't clear within that number of days, then one or the other can terminate the contract.
I think the EBA contract is 30 days.
It's 30 days.
30 days, and then either side can walk away.
That's correct.
And one thing that we don't see in the EBA contract, but we see sometimes in other force majeure clauses, is a notice requirement. That you can only claim force majeure if you notify the other party. Presumably in this case, there's less of an opportunity for a party to take a force majeure claim and put it under their hat because there's a time frame for closing. And
Well, right, and where that becomes more of a factor is, say, in a build contract, a construction contract, where you might have to shut the yard down for a few days because of a storm, or there can be events that occur during the course of construction that may not be more than a few days long, and you put in a notice requirement so that you can evaluate whether it was a true force majeure event at the time, rather than 2 years later when the boat's being delivered, the yard say, oh, and by the way, I have 20 days of permissible delay here because of that huge storm we had, back then. And so that's the purpose there. But as you say, in a purchase agreement, you're working with tight time frames, and everyone knows if there's a claimed excuse not to perform, so notice is less of an issue.
now, Mike, you saw Mr. Ficarino was very eager to keep the deposit. And if he were to try to do that, what would happen? And assuming the buyer wasn't just going to roll over.
Well, assuming the buyer wants to do it, he's got several options. One, looking at the contract, there's probably some sort of clause in there in which to have a dispute resolution. Often it's an arbitration clause. I sometimes say, sometimes jokingly, a lot seriously, many people don't read the back pages of the contract where you have a dispute resolution, jurisdiction, venue, and arbitration clause. And when there is a problem, I think that's when people finally turn to it and say, there is an arbitration clause. Should there be a dispute arising out of this contract, it is going to be settled by the American Arbitration Association, the Miami Maritime Arbitration Council, or the International Yacht Arbitration Council. Some form in order to determine how to do this. Usually one side, or who has realizes there a conflict, is going to invoke the arbitration clause and then put it into a position where someone's going to make a decision rather than suing someone. If there is no clause, their only alternative may be going to court. This is a way to do it, so we do it amongst ourselves quickly, hopefully cheaply, and getting this done.
What does a typical arbitration look like from start to finish?
Generally, and in a purchase situation, someone has a dispute. One side will invoke the arbitration clause, and they will contact the arbitration council.
I'll ask you one question there
Sure,
before you go forward, and that is that a lot of times you'll see will be decided under the rules of so-and-so and so-and-so. Does that necessarily mean and under the auspices, meaning you've also signed up for them to administrate the arbitration?
Generally, yes. However, the one thing, the beauty of arbitration is we are doing this amongst ourselves. And the idea, so if you are on one side or the other, and we've now looked at the contract that was put together a year and change ago, and we realize, why are we going to London? Or why are we, we're here, you're here, buyer's here. We might use those rules or work it out amongst ourselves. The whole purpose of arbitration is we the parties have decided we are going to do this without going to court. Mm-hmm. So oftentimes someone may change. Often people may change and say, hey, it says let's go to London, but I don't really want to go. Do you really want to go? No, we're going to use this group.
Right. So
in that case, a lot of times the parties may work it out. That's part of my thing when I say they don't always look at the back page. They will contact the arbitration council. Both sides will get a copy of the rules. They will pick arbitrators. Depending on how it has been set up, you may have one or three. If it's one, we both agree on it. If we decide on a 3-person panel, I pick an arbitrator, you pick an arbitrator, and those two pick a third person off usually a list of qualified arbitrators, and that person has to be the neutral, and they set a schedule depending on how quick this is going to be, how quick the parties want it to be. The main consideration sometimes I think of arbitration is this is among ourselves. It is not a federal judge determining his calendar. This is us determining our calendar. Generally, the rules of evidence are somewhat relaxed. Sometimes it's done just on paper. Sometimes it's a matter of having, bringing in live witnesses. Again, it depends on the size of the dispute. But we have agreed, that once there is a determination, that's going to be it. There is no appeal. And it is generally enforceable. It's not generally, it's enforceable as a matter of law. Most judges look at it and say, you picked this forum,
Don't cry to me.
Yeah, don't come to me. You pays your money and you takes your chances. Mm-hmm. And also, most almost all countries that we're dealing with all recognize arbitrate,
the New York
awards by the
Convention.
Arbitration. The New York usually considered, the New York arbitration law. I forget. There's a whole list of countries. Pretty much everyone you're ever going to deal with.
And that's
is on
something
it.
to remember, because if you get a judgment, say in the U.S., that you need to enforce in another country, that's a more involved process than if you get an arbitration award, provided that that other country is a party to the international convention.
And that way there are no questions sometimes where another country may be looking at it, or one coming here, a judgment coming here from another country where they're not where they're asking questions. Was there due process afforded? And it's a whole nother lawsuit. Here, a lot of times a judge will say, you have an award, you all both agree to it, and they will turn it into a judgment, and it's enforceable like any other judgment. The sheriff will, the marshal will come and collect on it.
Now, you mentioned that if the parties choose a forum that turns out to be inconvenient to both of them, they can always agree on a different forum to resolve the dispute. I think one problem that comes up is when the forum is considerably less convenient for one of the parties, and then the other party can use that as leverage because he knows that the dispute resolution chose, home field advantage.
Absolutely. Home court advantage did not start in basketball. And so the idea of having it, I would rather do it here than do it somewhere else. And often one party may be located in New York or London and say, hey, you agreed. So the time to determine it is when we're all signing the contract, not 6 months or a year later, in a build contract or in a purchase and sale agreement where they're saying, did you know we were going to London? So read the contract, read the back pages.
And the other thing you mentioned was finality. When you go to court, typically you have at least one appeal as a matter of right if there's an error of law. But if an arbitrator makes a mistake, your remedies are more limited.
Correct. Almost all courts will say, unless there is something, blatant. It was my brother-in-law. There was some outright fraud, just a gross mischaracterization of the law. But as a general rule, courts look at it and say, the arbitrators made the decision, and there is no appeal. The good news for that is, in terms of time,
It's finality.
There's finality. There's not another year of going to court, and we're done.
But of course, if you want some sort of appellate process, you can always agree to that in arbitration.
Generally, but then again, it's agreed to beforehand,
right?
Not afterwards,
right?
Otherwise, it's this is my panel. They've made the decision, and we're going to live with it.
And does that apply, Mike, even say if the arbitrators make an obvious mathematical error, when they have a column of numbers and they come up with a total and the total is different than, it's just incorrect?
Well, generally they'll go back to the arbitrator and say, hey, 2 plus 2 really is 4 and not 5. Exactly.
Right, okay.
So,
you can, after you get the award, you have a right to go back to the panel or the sole arbitrator and say, hey, wait a minute.
Yes, and that's happened in times where someone may have you covered these 4 issues, but what about that 5th issue? Maybe we can work something out. And that really is the whole idea. We are doing it amongst ourselves, and also we're going to people who know something about the business. Judges has a general rule here, hundreds of different types of issues, and they may or may not know anything about yachts. In an arbitration situation, the list of people on the panel are lawyers or brokers or surveyors or someone who knows something about the business. And that's a good thing. And the whole idea, historically you had arbitration panels made from, London insurers who were all, knew everybody in the business, knew what was going on. And that's the same thing here. We like the idea of having an arbitrator who knows something about purchase and sale agreements or build contracts and such. So it's not a mystery to him. And I think both parties I think they get better service if they have someone who is familiar with the process.
Now, Dad, one thing that I've encountered from some clients is sort of a growing skepticism toward arbitration because they've been involved in an arbitration before that was lengthier or more expensive than they anticipated. Do you think in general, and I'm not talking specifically about maritime arbitration. I'm just talking about arbitration generally, and some clients are sort of skeptical. Have you encountered that, and how would you respond?
I think most of the time the client's attitude towards arbitration or judicial resolution depends upon which he did last and how it went. And I'm serious about that. If they had a very difficult arbitration that extended for same time as a court proceeding would have, and it was expensive, and he got a bad result, and he didn't have a right of appeal, he may say arbitration's not what I want. But if it was as it's intended to be, which is quick and less expensive, and you get a reasonable result because you're dealing with knowledgeable arbitrators, then he probably would think otherwise.
Mm-hmm. But I think most people in the industry would agree you don't want sort of a complicated yacht dispute in front of a judge who doesn't know anything about yachts or about the marine industry at all.
No, I think that's right. The other thing to point out is that arbitration takes away the jury.
Yes.
And there may be cases where you'd prefer to be in front of a jury or you prefer not to be in front of a jury, and arbitration is one way of managing that. Of course, you have to make that decision up front. You can't make the decision when the dispute arises.
And of course...
Sorry, and one of the other things about it is there is a level of privacy.
Mm-hmm.
Most arbitration panels are done in private. It is not in an open court. It's not we can go in the back and sit and get popcorn and watch what's going on. It is private. The results are not necessarily published. Some groups do, most don't. And therefore, I am not doing my laundry in public. So if you have cases between, builders don't want to have it known that they have dispute with clients. High net worth individuals don't want their business done in public. Brokers don't want to know that they're having issues amongst themselves. That way it is all done, once again, I use that phrase, among ourselves. Mm-hmm. And that privacy is important to a lot of clients.
And on the jury trial issue, we know there's no right to a jury trial in admiralty, but of course contracts to sell a vessel aren't
in admiralty.
So it's just a plain vanilla dispute that you can sue in state court and get a jury trial.
Yeah, and nor is a commission agreement, there's a lot of build contract. It's another example.
That's not. And it's almost the opposite. In the jury, you almost see where they're looking for 6 people who don't know anything about this case. In the arbitration, you're looking for people who know something about the boat business. Mm-hmm. And sometimes it's a better deal. And then the last thing I sometimes think, a large yacht owner is probably one of the most unsympathetic people in a courtroom. 6 people from the Broward County driver's license registry may not have a lot of sympathy about spending their day with a dispute amongst yacht buyers and sellers. Just saying.
So I know that EBA has been working on an alternative forum for disputes in the yachting industry. Do you want to tell us about that?
Yes, we have decided, and this is that overall theme may be of amongst ourselves, that rather than going to London or New York and such, that we should be doing these things here. So the IYBA has founded the IYAC, International Yacht Arbitration Council. The rules are written, the list of arbitrators are there. It's going to be published on the website. Hopefully it will be done by the time these things are done. And the idea is to have our own system of doing it. And part of it is convenience for the sake of, we're not doing it, if we're not doing this in London, we're picking our own people. We're picking knowledgeable brokers. And these are also ones where I think people who will be involved, brokers, lawyers, are familiar with who those arbitrators are. I just got a list from the AAA for an arbitration, and we're passing it around, and I have no idea who these people are.
What background they have.
But from what I can read from their backgrounds, the word boat is not in.
It's not in there, right?
So becomes an issue.
They took a cruise one time.
Yeah, so I think that has become, again, an issue. But yes, it's going to be up and running, and contact the IYBA office, and if you have a dispute, and they'll be there to help.
And you think the primary advantage of the forum is primarily the roster of arbitrators, the level of experience?
Oh, absolutely. And starting with local, known arbitrators, people who have experience in the yacht business. Even some of the arbitrators there's an organization in New York, the Society of Marine Arbitrators. I think they're outstanding for cargo cases. They do a lot of cargo. They do a lot of blue water shipping issues. We're in a different world, and so we want people who are more familiar with that.
That's sort of like the LMAA, the London Maritime Arbitrators Association, which is an arbitrable body it's purely for maritime issues. Mm-hmm. Although not necessarily solely admiralty issues. I mean, you could, for example, have a build contract or a purchase agreement decided through arbitration in
Or a
front
lot
of the
of
LMAA.
A lot of insurance coverage issues wind up in front of either the AAA or the LMMA.
The LMAA is the default, I think, under the MEBA contract.
Yeah, and it's also what you generally see in English law construction contracts too.
But a lot of people say that LMAA is fantastically expensive.
It is.
They're
Yeah.
not, they're,
Well, you have to remember, I mean, you have the two-tiered system in England where each party has a solicitor and the solicitor employs a barrister. And then you have the three members of the arbitration panel who are generally lawyers. And the wheel is spinning. I mean, the clock it's just a very, very expensive process. But that also can have advantages in the sense that each side knows it's going to be horrendously expensive to take this to arbitration. It's a real incentive for them to get together and settle it.
Mm-hmm. And can you talk a little bit about how these sort of arbitration provisions dovetail with fee provisions? I mean, normally is an arbitration provision paired with an attorney's fees provision?
Certainly would be in the US because otherwise there's no right to fees in arbitration.
Mhm.
But you can empower the arbitration panel to determine fees and determine who's the prevailing party. That's less necessary, say, with an English law contract because prevailing party attorney's fees are a matter of right, not a matter of contract.
But if you're under the American rule and you have an arbitration clause, you could still end up paying your own fees even if you win.
Yeah, I believe Mike could comment on this, but my understanding was the arbitration clause has to specifically refer to the arbitrator's ability to decide fees. And so you have to empower them in that sense. You just don't say that one party or the other is entitled to the fees. You say that the arbitrators are able to make that determination.
And often in the clause it will say the prevailing party is entitled to to their attorney's fees. So that putting it in, and a lot of the times the rules for the various organizations will have that the arbitrators have the ability to determine fees. Almost going back to the original contract. If the original contract has said they have the ability to determine fees, then the arbitration council will determine those fees if it has been provided for in the original agreement.
In the contract. It doesn't
Yes.
create a separate right to fees. It's just
Correct.
they will adjudicate fees if the contract allows for recovery of fees.
Correct.
Now, Mike, if you're drafting an arbitration clause, obviously you want to say what the forum's going to be, how you're going to pick the arbitrators, although that's sometimes covered in the rules. What other sort of points do you want to hit in an arbitration clause?
We'll certainly venue. We're going to do this in Fort Lauderdale, or we're going to do this overseas. Choice of law. A lot of times you'll see in arbitration clauses, and we will use the General Maritime Law of the United States or the state of blank as applicable. And again, where often it'll be or London, wherever. But you want to make sure that is clearly laid out. That's usually in the in the dispute resolution section, which will include jurisdiction, venue, arbitration, choice of law, question of attorney's fees, etc. So those things should all be laid out. And someone will lay out, 3-person arbitration versus 1 person. Sometimes that is depending on the amount in question.
Yeah.
Small boat, small issues, we don't need 3 people.
Well, or if you can't agree on one, then each party picks one, and those two pick a third. So.
And often the rules, sometimes in most arbitration council rules, will say if you cannot pick one by a certain date, we will pick one for you.
Right.
So.
Which is one of the values of having an arbitral body like that, because they can serve as sort of umpires and, okay, guys, you couldn't agree. This is what it's going to be, as opposed to just leaving something hanging.
I've seen ones where they have said, where someone has written back and said, if you guys can't agree, we will pick one for you. And by the way, we have picked David as that person. So
the parties can evaluate whether
or this guy or whatever. And often that solves it right there. They're, oh, we like David. So off it goes.
Yeah.
But I've seen that happen. But those are the kind of things in the clause. We're going to arbitration, choice of law, choice of venue, attorney's fees, 3 persons. Some people put time issues in there and such. But again, the whole idea is, we can do this amongst ourselves. We can do this quickly. If the purpose is to either buy the boat or sell the boat, some of the times the issues are not make or break. They may be simpler issues on, a little bit, payment on one last cost or damages or something. And therefore it can be done quicker, and sometimes it may just be, a quick issue that, we'll get a 3rd person in, we agreed on an umpire, let's go. So rather than, and suing someone usually is not the best way to make friends. This is a little more business-like, a little.
Mm-hmm. All right, well, I think we're going to leave it there. I want to thank Dad, thank you for coming, and Mike, thank you for coming. I appreciate your time. We're going to take a break, and when we come back, we will have Act 6 of As the Prop Turns. Thank you.
We would like to extend a very special thank you to our friends over at Alley Moss, Rogers & Lindsay, PA, for their continued support of Yacht Sales and the Law. This 25th edition wouldn't be possible without their generous endorsement over the years.
Maritime arbitration has been around for hundreds of years. Now we have a new forum to solve our disputes. The IYBA has created the International Yacht Arbitration Council to solve our disagreements. We have experienced maritime attorneys and yacht brokers to serve on our panels, people who know the law, who know boats, and who know the yacht business. IYAC arbitration can handle yacht claims, contract, purchase, and commission disputes privately, quickly, and less costly than going to court. Sometimes disputes happen, and when they do, the IYAC is here to help you solve them.
IYBA would like to thank Howard S. Reeder, Inc. for their support of this year's 25th Annual Yacht Sales and the Law.
Okay, based off the lightning strike that we had, looking at the list of all the work that needs to be completed, you're telling me we can get this done within $150,000 and within 30 days?
Absolutely.
Okay, great. I'll inform the owner. Let's get started.
Done.
Thank you, sir.
I'll see you soon.
Bye-bye. Time to call the owner. Mr. Vicarino, Bill Boatwise, how are you today?
Hey, I'm good, Bill.
I do have good news. I just met with the project manager of the Lauderdale Marine Center, and he assured me all the work that needs to be completed can be completed on time and on budget. That means we're not going to lose this deal. We're still in it. We will get across the finish line. No, I'm actually supposed to be meeting with him very shortly. I gotta go. This guy's walking in right now. Okay, thanks.
Y'all must be Bill.
I'm
Bubba.
You must be Bubba.
Nice to meet you
Nice to
finally,
meet you
fella.
too, Bill.
Golly,
Grab
it's
a
been
seat.
a long road to hoe getting here,
Yeah, it
hasn't
kind of has been, has it?
Yeah, man, we done drove down from Brunswick yesterday. I dropped
Okay.
Daisy off. She's over at the Galleria, man. She's out spending my money already.
That's probably not a good idea.
What do you mean it's not a good idea? We're closing tomorrow, man.
Bubba, I've got some news. We're not closing tomorrow.
What do you mean we're not closing? I came here to close.
We're not closing tomorrow.
But
During
the money's in the bank.
the Tropical Storm Omega, the boat sustained a lightning strike.
Well, what happened?
Well, there was some damage to the boat during the lightning strike, and per the contract that we have, the seller has up to 30 days to address the items that were damaged and up to 5% of the value of the boat. It's all
man,
here in the
how
contract. I've sorted it all out.
Okay.
I've talked to a project manager,
man.
and he assured me that we would be able to get all the work done on time and within budget. So you're gonna have to go back to your buyer and explain to him that we have another 30 days before we can close on this boat.
You gotta
And
be
that's
kidding.
up to you to do that.
But
He signed this contract. He's gonna
Lord.
you're gonna have to relay it to him.
Bill, you got to help me with this, man. I ain't never had nothing like this happen
Bubba, this
before.
is the tough thing about being a yacht broker. Sometimes you got to make some difficult phone calls to your customers.
Oh.
The seller has
When-
up to 30 days and 5% of the value of the boat to fix the items that were sustained since our survey. It's very clear.
So it might be 30 days before we can close again?
Correct.
Lord, I'm going to have to make a payment before then.
Well, you should probably stop buying things until we've closed. That's just my
Oh,
suggestion.
Lord.
But hey, so
Man, they
we
told
have
me
a
to
little
dress
time.
for success down here in
It's a
Fort
good-looking-
Lauderdale.
That's a shirt.
It's a shirt. Yep.
That's a shirt.
It's a shirt. Oh. Hot tub, piece of the pie. Sugar mama with a whole lot of zeros and commas. Yeah, she loves me. She could even be ugly. Won't marry for money. Hey, Bill. Yeah, hey, I got the new instructions. I'm at the bank. I'm getting ready to send that money. Yeah, Nigeria, right, just like you said.
Welcome back to Yacht Sales and the Law. We just watched Act 6 of As the Prop Turns. I am joined for this panel by Jeff Cox, maritime lawyer at Cox & Company, and we have appearing remotely Mike Wills, the co-founder and chief data officer of CSS Platinum. We're going to talk about a few of the issues raised in that act. First, we're going to talk about some of the issues around damage to the vessel subsequent to acceptance before closing. And then we're going to talk to Mike about some issues raised by the wire fraud or attempted wire fraud we saw there at the end of the act, where Bubba got some fraudulent wire instructions, very nearly used them to send the money to Nigeria, and then the FBI got involved. But first, let's talk about this issue of damage. What happens contractually when the vessel, after the buyers accepted the vessel becomes damaged?
Well, thanks for having me here, by the way. Good to see you again. Assuming that they use the latest version of the IYBA agreement, if the vessel is damaged after survey and acceptance but before closing, and the damage amount is less than 5% of the purchase price, then the seller has up to 30 days to rectify the boat back to its original condition. So that could be either welcomed or not welcomed, as the case may be. But that's the situation.
And I suppose if it were more than that, if it either cost more than 5% or would take longer than 30 days, they could always agree to give the buyer, to give the seller more time to complete the work and still
if the guy wants the boat, if you have a willing buyer and a willing seller, they can do what they need to do to make the deal happen.
But the buyer would have the option to walk away.
The issue is where you have a guy who says, I no longer want this boat.
Right.
And the seller says, too bad.
Now, what would happen if there was a dispute over how much something was going to cost or how long it would be expected to take?
Well, the contract would have dispute resolution mechanisms built into it, which you would look to, but probably as a matter of first instance, we would have a surveyor go, and maybe more than one surveyor if it was a particularly heated dispute with a lot of dollar value to it.
If you were going, I mean, if it's a purely factual question of how long work's going to take, it seems silly to go to arbitration over that when you could just choose a neutral surveyor and get an answer.
Sure. And there may be an argument about whether or not a prediction that it'll take 30 days is realistic or not. I mean, we know how it is. I mean, shipyards have their own calendar. When they say 30 days, you might hear 90, or you may believe them. You know, but there could be an issue there too that you would have to watch.
And when you see in a contract, either when you're talking about damage after acceptance or work that's being done because it was found in a survey, usually there's some provision that the buyer surveyor has to sign off on everything and say the work's been performed adequately.
Yeah, that's a smart way to do it. Have the surveyor go back and certify that yes, this work has been done. It's in proper yacht condition, et cetera, et cetera.
Now, are there other issues in addition to damage that could come up between acceptance and closing that could change the deal or create an obstacle?
It's possible, but what you're concerned about is during that period of time when the buyer is now bound and you have not yet closed. I mean, it's possible that a lien could have arisen for whatever reason, fraudulent or otherwise. I mean, it's possible. It's possible that one of the parties could become incapacitated. I mean, it's possible that any number of things could happen, and that's sort of that period of time where we try to tell our sellers to do whatever they can to not change the status of the boat. Don't take it out for one last party. You might hit a log. Don't take it out. Don't leave the dock. Keep it clean. Keep it ready to go, and get ready for a closing.
And the EBA contract, I think, says they're not supposed to use the yacht after closing except to move to the delivery location.
Right. Yeah. Which is good advice. Yeah.
And obviously, the reason we get documents like an abstract title or transcript closer to closing is because even if you order them before acceptance, something else could be
Exactly.
recorded
Exactly.
in the meantime.
Yeah, something could be recorded. You know, it wouldn't take but a couple of days to do that. So we try to bring the transcripts and the abstract and title closer to the closing date. There's also liens that could arise that don't require recording, which if the boat's used is more likely to happen, but it could still happen while it sits at the dock. I mean, it's possible.
And the only way to protect yourself against that is a warranty of title.
Correct. And that's why it's important to only buy a boat from what I would call a solvent dependent.
Right.
You know, so you don't want to buy a boat from a guy who's filing bankruptcy.
Right.
Because you're taking a leap at that point. So
now I've been in a lot of situations where, for various reasons, whether it was because work had to be done or because there was some wrinkle in the deal we had to fix, closing got extended. Both sides agreed to it. You know, in my experience, sellers are generally willing to do that. The only concern is carrying costs.
right. Yeah, we've had situations where the carrying costs have been negotiated. Situations where closing's extended and buyer wants to start on a couple of punch list items, or buyer wants to, start modifying the boat, which is usually, when I hear that, I get cautious though, because that's how problems arise. When you have a guy who does not yet own a boat, who's bringing on contractors and things like that, that's where, he might start into this project of making a modification to the boat pre-closing and find, oh, but I just discovered something that I did not discover at survey. I no longer want the boat. Now you have a situation.
Yeah, that's always,
yeah.
I mean, it's one thing to have the buyer's crew on board, familiarize themselves with the vessel, but even if the boat's already been accepted, the buyer can't back out to have them on board doing work.
Right.
I mean, among other things, I would think it raises an insurance issue because he's not the insured, and
it could.
Potentially he could damage the vessel.
Absolutely. Yep. There's a lot of reasons that you want to freeze time in between acceptance of vessel and closing as much as you can.
Right. Although we like to leave enough time so that, for example, we have time to set up an entity to own the boat.
Yeah.
And I mean, I would say that the tightest you could do it in is maybe a week or a few days.
Well, we won't admit to how tight we have done it in the past.
That's true.
Yeah.
The tightest.
2 weeks is a very comfortable period of time
Right.
for us to do what we need to do. More than 2 weeks, we're just waiting around. Less than 2 weeks, it starts to become a fire drill.
Yeah.
So that's 2 weeks is a really good period of time. It allows us to form an entity and get the documents that we need. It allows, to the extent that we're going to be involving a bank, it gives us some time to absorb the delays that come with borrowing money, and we can fit it in there. And it's still reasonably close enough where you're not getting undue pressure to get the deal closed, because everybody wants their new boat and everybody wants to sell the boat while they have a buyer. So there's a lot of pressure to get it to closing quickly, and that's understandable. And to do well in this business, you have to be able to get that done. But if you go too fast, you run into risks, and if you stay too long, you run into risks.
Financing can be an issue because sometimes even if a buyer's gotten a loan commitment before acceptance, he gets the loan documents after acceptance and sees something he doesn't like. And so you have to either look for another lender or try to negotiate it. In the meantime, you're pushing back closing.
Exactly. Or you better be ready to pay cash and then refinance the boat after closing, which means typically liquidating productive assets and going through a whole fire drill with your financial guys, to get the cash ready to close if we're talking about a big boat.
And if you have a seller who's not willing to cooperate and doesn't want to push back closing, they can make it difficult. Although I've always thought that if a seller really wanted to try to hold a buyer in default, usually, unless the seller is very well represented, you can find something to nitpick in the closing documents or how they're going about doing things.
You can.
But in my experience, most of the time, there's a deal to be had to extend the closing date and get everything in order.
The other thing too is that you don't want to be accused of being unreasonable. I always try to tell my clients to try to keep the halo on their head and the horns off of their head. If you start making unreasonable demands as you get close to closing date, it's very easy to see how you could be painted as the bad guy, and then the judge will tell his clerk to go find me the cases that make this guy win and this guy lose.
Mr. Ficarino, he's just an off-screen character in the skit, but he's clearly has very strong opinions about how he wants the deal to go.
Right.
And just talk a little bit about how you manage clients who maybe haven't done a boat deal before or have very strong feelings or expectations, and how you manage those.
It's case by case. I mean, the nice thing about our sort of work is that we have wealthy people who have been successful. Every one of them has had their first boat deal, though, and depending on their personality, we have to adapt how we present the way this thing plays out to them on a case-by-case basis. Some people on one extreme will say, Jeff, just tell me when I own the boat. And that's the last I hear from them. And other ones are hand-holding the whole way through, wanting to know, is it soup yet? Is it soup yet? Where are we? What's going on? So it's different with each case, but ultimately the trick is to get on the phone with them and talk to them and let them understand what's going on. I find that emails don't help in situations like that. You need to get on the phone and have a conversation with your client more often than not.
It's a little more difficult for me as a millennial being afraid of the phone, but I do have to force myself to make those calls.
Well, you can be a late adopter, but the phone's been around for a while, so I'm still with it. I'm Gen X, I guess, but the phone is handy. There's too many ways to misinterpret emails that could inflate or make a situation that maybe wasn't a bad situation become a bad situation because of people. Not everybody's a lawyer. Not everybody does English very well. And then you read these emails, and it's so easy to have an email poorly written, totally misinterpreted, and now you have a major problem that never really should have even been a problem. So the phone is handy for that. And particularly when you're talking to a client about how a deal could go down, you can get an immediate feedback what the reaction to it is and see how they feel about it, and then adjust as you go.
Yeah, it's always good to prepare them for different situations that could arise.
Nobody wants to be surprised, and everybody wants their toy. So that's what you have to keep in mind. I mean, people don't want to find out 2 days before closing that it's going to take another week and a half, because they've already made plans and they have family coming in and they're going to show off their new boat and everything else, and that's not a good situation. So,
but sometimes you have to put the brakes on, and there's an issue that comes up.
Sometimes it is what it is. And sometimes that's where email comes in. When you have to put the brakes on, you say, as we just discussed, and then you tell them how it is. And obviously they can instruct you that they don't care and they're willing to take the risk. And in some cases, that's what they can do. In some cases, it's just not going to happen. It depends. If it's a situation where a bank is required to close, the bank doesn't have a lot of flexibility typically because they have an underwriting team or individual that just is not going there. So it depends.
Another issue that occurred to me you have when there's damage post-acceptance is potentially insurance, because the insurer has already reviewed the survey, the pre-purchase survey. Presumably they've either signed off or required the seller to do some work, but obviously if there's damage after acceptance, that process starts over. They
Absolutely,
have to be satisfied
they're going to need another
again.
survey at the end of it. They may need another survey entirely, or they may just need the surveyor to go back and give them a update on the new damage.
So even if it doesn't take 30 days to repair all the work, you probably need a little bit of time after that to get everything.
But they'll still find a way to take your premium. They will they'll come up with some way, and they'll put an asterisk next to it and say that if this wasn't done correctly, then any future issue that might arise out of this won't be covered. So you really need to make sure that your client understands that and doesn't do something that will cause them to send premiums to an insurance company that will never insure their boat, but they will take the premiums.
And that's actually something we talked about on an earlier panel, is how difficult it's become to insure some of these boats.
The insurance companies have been killed.
They've
been they don't want to put their hand up. I mean, you try to get an underwriter to take a risk, and they're just going to put their head down and hide and say, "Don't look at me, I'm not doing it." So they've had natural disasters, they've had yachts burning at the yard, they've had all kinds of things happening over the last couple of years. Aviation to some extent as well, but the yacht, at least that's the story that I'm hearing from insurance people that I deal with. It's just that they've just been shellacked. So their risk tolerance is way down. They're trying to reduce the amount of yacht exposure they have on their portfolios. And again, not that we're talking about that, but aviation has had a similar kind of a year. They're just not interested. It'll change though. Greed will come back. There'll be a few years gone by where they haven't had the loss history. Maybe there won't be hurricanes or fires or something like that, and they'll realize that those premiums were nice and they'll want them again. So it'll go in waves and ebbs and flows. So,
well, one of the other issues we saw on that act, the last Act 6, was the wire fraud issue. And that's something that's become a major issue in our industry. We've talked about it at a few of these seminars before, but obviously it's still an ongoing issue, and I wanted to bring in Mike and see if he could tell us a little bit about where he sees the biggest risks and vulnerabilities for our industry with wire fraud and other kinds of cybercrime.
Hello, gentlemen. David, thank you for that. And Jeff, lovely to meet you and good to be part of this. It's really interesting, a question here. And I think one of the key things to understand is that cyber criminality is not very much different from criminality that we've known since the beginning of time. It just so happens now that it occurs in a digital environment. And ultimately, these criminals want to steal things, whether that be money, whether that be information, whether that be people, God forbid, in kidnap attempts or something like that. But ultimately, they want to steal things. And the problem that we see from my company, CSS Platinum, is an understanding of that within the industry. I mean, reputation is key in the industry that we operate, and it's very important to all companies and peoples and owners out there. But because of that, what we often find is that people are not willing to either publicize unless they absolutely have to, or admit that cyber attacks have happened, because it's embarrassing. And it's viscerally distressing, and therefore it's a very difficult thing to admit. And the problem that then gives us is that the industry can perceive that it's not necessarily a problem. Where's the body of evidence? Where's the case studies? We're just not seeing this sort of stuff happening. And it can be an element of naivety to the facts because it's just not being reported. So we see that as one of the key areas that people don't necessarily understand just how present, a clear and present threat this is. And if I may, David, just to go back to one of the things that you and Jeff have just spoken about, it's quite interesting. You talk about damage before handover. That's not necessarily my expertise, but it wouldn't surprise me in a period of time in the near future. Damage doesn't always need to be visible. It doesn't need to be damage in the sense of impact or crush or chip or whatever. The damage could be cyber related. So, for instance, what would happen if just before you're handing over the purchase of a vessel, a cyber attack happens on board? How would that affect the way that the transaction may or may not complete? And then that also then begs the question is to say, well, what about the owners? How do you assure a potential buyer, particularly as we move into the period of time where ownership will be with people, to use the term millennials and such, like they've grown up in a tech environment, who might have more discerning needs, as if to say, well, hang on a minute, how can you assure me that this vessel that you're passing to me is free of cyber infection, free of virus? How do I know that if when I take ownership, there isn't already going to be something lurking on there that could cause me damage or problems later online as we go through? So I just wonder, I don't think we've seen it. We certainly haven't seen it yet, but it might be something that raises its head in the near future.
No, we're already seeing something similar to that, not involving cybercrime, but it used to be when you bought a boat, you wanted to be sure the boat came with the tenders and equipment and inventory. Now you want to be sure the boat comes with the tenders, equipment, inventory, passwords, intellectual property, all the stuff that you need to operate the electronics on the boat. The boat's marketed for charter. She has a website. You need to have the URL and the domain and access to that. And there's a lot of sort of non-physical stuff that comes along with buying a yacht these days. Yeah. And it strikes me that the integrity of the data systems on board is now one of those things.
I mean, it's interesting when you speak there. So what you've described there is the digital landscape or the digital domain that surrounds the yacht. And it's vast. It's not just the yacht in itself. It's also the people and the supply chain and the ecosystem that are associated with the yachts. And again, let's just spend a little bit of time about understanding, who are the types of people that are going to conduct a cyber attack. And we're not just talking about, hooded script kiddies that you read about and hear about, sat in a dark room playing on their computer. We're talking about every potential strata of criminality, right from the wannabes that just want to have a go because they want to look cool in front of their mates, to highly organized, sophisticated criminal gangs that operate this as a business. These are strategies that are resourced both in terms of money and time and people, and they're really, really patient. And I would be more than certain that for the majority of very large and prominent super yachts, there are dossiers being prepared by multiple criminal gangs the world over to understand what is the attack vector, what can we do, how can we look to target these people, what is it that we can potentially steal, what is it that we can do. But these things don't happen in isolation. And this is where the industry needs to understand it's not just one group that might be trying to perhaps prosecute an attack on a super yacht in terms of stealing something, again, back to money or information. This is also about understanding that every level of competency from a cyber criminal is all happening at the same time. It's like a barrage. And, we see in phishing emails and scams in our emails on our devices really comical attempts to do things, but there will also be very, very sophisticated attempts to do these things as well. And the thing with a cyber attack, and we've spoken to owners, they're like, well, what's the point of doing a cyber attack on a super yacht? Why would we do that? But the key thing there to understand is, the cyber attack is just a means. It's not the end goal. It's a digital crowbar or it's a digital rock through the window. The cyber attack enables them to achieve the thing that they want to achieve. And when you're dealing with the types of people that we know that own super yachts and understand the world that goes around them in terms of their success from a business perspective and where they might be operating in what industries and sectors, it might be that the criminal gang said, do you know what? We want to target this individual. Where can we do that? And it might be that they decided that they're most vulnerable on their super yacht. So a cyber attack is then prosecuted onto a super yacht. But that doesn't mean that's the end goal. They might look to plant something in there, which still then has a journey to travel. That it needs to work its way maybe onto the owner's phone or the owner's device when they connect into the Wi-Fi, which they then take away. And over a number of weeks or months, they then might move between the various places from which they operate in and connect to different Wi-Fi settings and plug in different devices to their laptops, which then potentially gets them into other networks. These people are very, very patient, and they often have a very, elegant and grand strategic goals that they're looking to achieve.
Can you talk in general terms about some of the strategies that owners can use to protect themselves against these kinds of attacks?
Yeah, absolutely. And I'm very conscious that, we do need to address the wire for it. We start off at the beginning of your question. I mean, the key thing about cyber resilience, in fact, the first thing I would say is, as much as we would want there to be, there is no security program is infallible. If somebody wants to get in and steal something, they can. And you only need to look at some of the very prominent examples in the media to do with Sony. There was a feature film stolen by a country, I won't go into names, but everyone knows who it is now, in order to be able to send a message. And they would have had massively resourced cybersecurity. So if someone wants to get in, they will. However, the trick to this is being hard to hack. How can you make it difficult so that they cannot get into that? And if it takes too long, that means it's going to take more time, more money, more cost, more exposure. There is more chance of getting caught. And the last thing that a cyber criminal or any criminal wants to do is get caught, because then they can't conduct and prosecute crime and they can't make money from it. So in order to be able to do that, you've got to make sure that when a cyber program goes into place or a security program goes into place, it has to be proportionate and it has to build resilience across a number of areas. And to put it in simplistic terms, and there are lots of frameworks out there that you can work to, but in simplistic terms, you're talking about governance. What gets planned gets done. We're sat now in an era where 5G is coming in. 6G is operating out in Japan at the moment. Everything that we use now has some sort of chip in it and is connectable to a network. Things are becoming smarter. You're putting sensors in there as part of the Internet of Things, and to be able to lower the intensity or just be more useful. These things all can connect to networks because they need to communicate to do their job. Every single one of them is then a point of attack. So it's a case of saying, right, I understand that this cyber problem is not going to go away. It's going to keep coming. If anything, it's going to get worse and it's going to get harder. And that means we have to govern this. And if we're going to govern this, we need to do this from a number of perspectives. We need to resource it in terms of money, because actually, you need to pay for the support to be able to do this. We need to resource this in terms of people. Who are the right people? What's the right support that we need to do this? And we need to have plans and policies in place that, one, help us think and plan and make sure we're doing the things that we can, but also response plans and recovery plans. So when things do go wrong in what can be a very high-risk area, as we know, out on the ocean, out at the sea, that we're able to manage this effectively. So that's point one, that governance has to be key. The second point then is about securing your people. People are your biggest asset, but they're also your greatest vulnerability. If I'm a cyber criminal and I can't target the owner specifically or the yacht specifically, I'm going to move my area of influence out in rings around the around the owner. Consider it like an onion skin and working from the center and peeling back the layers. how can I get into those? How can I get to the boat? How can I get to the owner? And so you're going to start to target people in the peripheries. Now, that could be the crew. That could be guests coming aboard. That could be business associates that come aboard to conduct meetings. This could be your suppliers. We've already talked about how digitally influenced a super yacht is. When we're doing diagnostic and maintenance, actually what you're finding is people will turn up with palm-held devices or smart devices and tablets, and they'll start to plug things into the super yacht. How do you know those things aren't already infected with some sort of malware, and that's now been put into the network on board the boat? So this is about understanding people and the way that people can do that, and in particular, the risk that people can do. I could talk a lot more about the threats from the dark web and how it's a criminal underworld out there, and there's already information in great swathes available to be stolen by criminals because other companies out there, and we'll all know them because they get publicized in the media, haven't secured their information. That information gets breached by a successful attack. It then gets put up for sale into a marketplace on the dark web, which criminals can buy for cents on the dollar. They'll then use artificial intelligence and pre-scripted bots to barrage web portals. And this is how wire fraud can happen, to go back to the point that we're making. You'll have some sort of script or algorithm that will take hundreds of thousands of breached pieces of emails and passwords, and they'll throw them at the web login page. Be that for Gmail, it could be for Hotmail, it could be for AOL, it could be for Microsoft or whatever. And all of a sudden, these algorithms will then say, hey, here's a successful password email combinations. And they're then sat inside somebody's email accounts. And they can do a number of actions from that. They can sit there and say, right, what's in there? What are they doing? And if we go back to the example that we've seen from the vignette, if it's a broker they just happen to stumble upon, or they've actually done some homework to say, we know this guy is brokering, let's see whether we can buy his information on the website and therefore get into his accounts, that's when they can start to say, right, what's the traffic of email going in and out? And what most people or most criminals will do is they'll set up an auto-forward rule because they can come into an email account, but they don't want to spend time in there because there's a greater chance of discovery. So they'll put on an auto-forward rule. And this is why, as a defense, multi-factor authentication is just so important because it gives you the knowledge as the owner to understand, is somebody logging into an email account from somewhere that shouldn't? If multi-factor authentication isn't on there, you won't know about it. So you don't know that they've gone into your email account. You don't know that they've set up an auto-forward rule. And that means that they get these emails and they can delete them from the email accounts so that anything that you might send doesn't get to its end recipient. So to go back to our example here, if this end receiver in Nigeria is sat there, and I've seen this happen multiple times, you get into the right email account, an email comes through which looks like a big payday. And they could have been monitoring these accounts for months and months on end. And all of a sudden it comes in and finally you've got the figure, what they're asking for, and you know that you've got the bank account details. At that point, what they'll do is they'll start to change the information, put in their bank account details that they want the money to be sent to, or the transaction to be sent to, and then they'll forward it on to its end recipient. Now, you would be very surprised amongst the turbulence of everyday life and everyday work, how often, because people are busy or they're having an off day or they're just not concentrating, they will accept an email that lands into their account as trusted. On the face of it, the person that sent it, you recognize, but they're just saying, oh, we've got a new bank account. Now, there are a few things that can be done here and what I would suggest people need to live by. If you're ever working in a business and someone says that you're due to send me some money, we're changing our bank accounts, and it's anywhere near a big transaction date or an invoice date, you have to be as cynical as anything. Okay, this seems odd, and they've got to have systems and processes in place when you can get hold of the people that are sending this and verify that. Don't trust the telephone number that's on the email because they've probably changed it because they're really, really cunning. So use an older email, or use the number you might have in your phone and go back to the source and say, can I just verify that this has been done? You might also talk about saying, well, hang on a minute, we're talking about a very large transaction here. You've changed the bank account details 3, 5, a week, 2 weeks ahead of the main transaction. Let's just do a small drop of money. Let's not do everything in one fell swoop. Let's put in $100, $1,000, whatever. Let's minimize the scope or the exposure about the money that can be stolen. So again, and this is the things for the accounts departments, for brokerage, to make sure that people understand if something changes, what are the steps, what are the systems, what are the processes that we can put in place to make sure that we're mitigating the exposure. And we're absolutely certain that this is a bona fide change in bank account or a bona fide person at the other end of the email.
You know, another concern that a lot of owners have that I think is related, it's not a security concern in itself, but perhaps it presents security concerns, particularly with very large yachts. There's sort of a community on the internet of people who follow them and post pictures and say where they are and speculate or provide information about the owners. And we've had owners come to us several times and see if we could get this taken down. And in many cases, it's simply impossible. I mean, the truth is there's a certain amount of information about super yachts that is either public record or easily discovered. And it can be very difficult for owners to accept that and to understand what, if anything, they can do about it.
That's definitely true. I get phone calls. Oh, Jeff, your client is in such and such harbor. I was like,
securing the people. And it's not only about what is the digital landscape of an individual, be that a crew member, but there's also the digital landscape of the owner. What information is actually out there about the owner, not only on the open source on the World Wide Web, but also on the dark web? Because the dark web is where the criminals will gather various bits of information, and just like our armed forces do when they're on operations around the world, they take pieces of information and they fuse them together, and that becomes intelligence. When you have intelligence, that then enables you to target people, to target owners, to target vessels. So actually, my company does a product called Yacht Check, Exec Check, and Crew Check. And what that does is we will go and we're able to look across all layers of the web and say, right, for your crew, this is the information that's out there, which criminals could use to either bribe, coerce, subvert them into doing things either by accident or because they've been compelled to do it based on the information that's available. Similarly, what's the information available out there in terms of yachts? What to your point, what's out there? What's on Wikipedia? What can you Google? What information can you find? What's it already telling you? How can that information be fused with other information to create intelligence? And the same for the owner, maybe the family. So the only way you can control this is to fully understand at any given time what's out there. And once you know what's out there, then at least you know how that might be used against you and whether it's a risk vulnerability to you. Once you've got a risk vulnerability, then you can come up with a strategy to sort it. But unfortunately, back to your point, that you can't always take that stuff down. But if you can minimize it, then that can certainly help.
There are a lot of, I've been surprised in some cases how you can't rely on people to use good judgment. I mean, for example, I had an owner a few years ago who had a crew member who was posting pictures on social media of herself on board with his children. And to him, it would seem that, of course you wouldn't do that. But I don't think it had struck her as a problem. And after that, we updated our employment agreements to say that, you can't put anything on social media without our prior consent. These are very private people, and they want to minimize their footprint online as much as possible. But a super yacht is, especially with a lot of crew, it leaves a big footprint.
Yeah, you have 20 people running around, all with phones and iPads. That's a nightmare.
It's difficult to manage.
Yeah. And if you don't put it on Facebook, it didn't happen.
Right, exactly.
I mean, the problem is that these, the social media is so prolific now. There's a new giant that pops up every year. And there are privacy settings. They've been made to do it just recently. There's a fascinating series of things on Netflix about the social dilemma, I think it's called, or something like that. But, they're being forced now to make it easier to put in privacy settings. But that takes time. And, people, unfortunately, are busy. The world moves so fast now. There's so many distractions from 24-hour news, social media, phones. The phones are constantly going bing, bing, bing with things going on. But actually to find the time to be disciplined and sit down and say, do you know what, I'm going to make sure that my social media settings are set so they are not public. And that can be done, but it means you just need the support of someone that knows how to do it. Particularly from an owner's perspective, maybe they want it to go public, or it's about making sure that they understand that they can narrow the breadth with which they shared. But if that said, that means you then are also relying on other people that may not take perhaps images or other bits of information, share it on outside of that bubble of trust. So that, I mean, that comes down to a mutual understanding amongst people as well.
Yeah, I mean, it strikes me that if I was an owner, I'd want that to be part of the onboarding procedure for a new crew.
Yeah.
You sort of go through their social media and see what the privacy settings are. And I don't know how many people are doing something like that.
I don't think many. I'd like to bring this back a little bit too to the brokers just for a moment. For anybody that doesn't know me, I was a yacht broker for 10 years before I went to law school. So I have a soft spot in my heart for the guys that are out there trying to make a living doing yacht brokerage. Also, I was hired as an expert witness on a case where a yacht broker had their email hacked and actually did send out proceeds to a fraudulent account, and it went all the way through the courts. Ultimately, the yacht broker was found to be negligent, and the damages were the amount of money sent out, which was a real amount. I mean, it wasn't a mega yacht deal, but it was a large sailboat. It was hundreds of thousands of dollars, not millions. The upshot of it is that the brokers have organizations like IYBA who have promulgated standards of reasonably prudent behavior that you must follow when you're handling money for your clients. And in this case, the broker that sent the wire was a member, and there was testimony that he read the manual, and there was testimony that he approved of it and thought it was a great idea, but then he didn't follow it. And they were, like I said, they were found negligent. So it's important to remember that you must have some kind of protocol in-house. Everybody's gone to, leave the last 4 digits off of the account number and make a phone call before you send the wire and confirm the last 4 digits. And I think that's a good step. The other issue was that in hindsight, when you went back and looked at the file, you could see the emails that were fraudulent because there was clues that perhaps English wasn't the first language, or something that if you were reading the emails, you might have noticed some misspelling in the names that otherwise you would never see misspelled, or things like that. There's just little red flags that particularly glow in hindsight that may have been glossed over first time. And those are things that people need to be looking for when they're doing a closing and getting ready to wire large sums of money.
Yeah, our friend Bubba, the yacht broker, doesn't seem like he would be
Bubba the yacht broker
good at detecting a fraudulent email.
He might have missed that.
Yeah.
But, you become a cautious individual when you have other people's money in your trust, and you must send it. And that maybe makes me read emails closer than somebody who's not doing that. But you need to understand, as a yacht broker, if you send the money out to the wrong person, you're not excused from sending it to the right person. You still need to come up with another set of dollars to send to the person who you're obligated to send it to. So that was the ultimate bottom line is, look, yeah, I'm sorry this happened to you. You were a victim on one hand, but guess what? There's other parties to this contract who still have rights and you still have obligations. And that's the way that the chips fell. And it's really the only just way that they could have fallen, if you think about it. So it's important to remember that, yes, there are security issues for yacht owners, but the yacht brokers who are out there doing this on a day-to-day basis have to be aware of this.
The situation you talk about with the broker who's found negligent, I think it's an issue that applies to both owners and brokers, something Mike was talking about earlier, which is governance. It's one thing to have a handbook or a policy or a set of procedures, but to be sure they're actually followed and who's accountable when they're not.
Right, exactly. Well, it's almost it's a gross simplification of the scenario, but you have, in a transaction, you have a contract and you have parties with rights and obligations, and those rights and obligations aren't excused because of the acts of a non-party criminal. I mean, if I owe you $100 and somebody hacks my account and takes $100 out of it, do I not owe you $100 anymore? I still owe you $100. Move the decimal point. There we are. It's that simple. So you have to be careful. You have to send every wire like it could be your last wire. Yeah.
Now, Mike, there was one more thing I wanted to ask you about that you mentioned at the beginning. Our problem in the industry, or one of our problems in the industry, you said, is the amount of secrecy around breaches and people who are victims of cybercrime. I understand why a firm or a broker would be reluctant to air that publicly, but what do you sort of recommend for people who are victims of cybercrime? What is the best way to respond to that?
So I was sat on a panel at the Boat International Design Awards in February in Cortina, and we had a discussion very similar to this. And after the event, a shipyard owner from Italy came to me and he said, "Is this stuff actually happening? I mean, you've just sent out a lot of examples, but I'm just not hearing about it." And so I said to the guy, I said, "Look, if your shipyard had suffered the cyber attack," I said, "who would you tell?" And in a blink of his eye, he said, "Absolutely nobody." I said, well, there you go. That's the issue you've got. The irony and the counter view to this is do you know what? People that get hacked probably go on to be the most secure people, because if it goes public, they have to respond to it. And if they survive reputationally, and if they are able to respond to this in a proportionate, diligent, and effective manner whilst communicating appropriately and dealing with all types of regulators and stakeholders in it, but they then go on and to demonstrate that they put in really robust security, they're probably pretty safe. And that's the irony from it, that sometimes it takes, an attack to occur to get people to understand that this can happen so easily. But in terms of the wider parties here, that, we've talked about governments, we've talked about policies, systems, processes. They should be rehearsed. And I know there's so much training that goes on, but even if they're tabletop exercises, if this happened to us now, what would we do? Who would we call? Where are our backups? How would we get this system back up and operating? Do we have insurance? Because if you need to bring forensics in, because you've been locked out of your accounts, or there's a very highly technical malware that's been uploaded onto an operational system or an informational system. At the moment, because cyber is such a growth area, across the globe, there just aren't enough people at the moment. They've got the skill set that we need to be able to truly and effectively fight this. Forensics cost thousands and thousands a day and they're in short supply. And, so you really need good and effective cyber insurance to be able to do that. But to do that, you need to find the right policies because, again, as with a lot of insurance policies, they can have some fairly stringent prerequisites that you have to achieve. Now, that might be ISO standards, for instance, 27001, cybersecurity. It could be any number of standards that you'll put in place. And, we've started to develop bespoke insurance policies with cyber underwriters rather than saying, well, we don't know how to quantify and qualify what the risk exposure is and therefore what the premium should be. So we'll say, well, hang on, why don't we take a risk-based approach on this? Let's look at what are the various component parts of security with cyber resilience. If a yacht can demonstrate that it's done all of those things, is therefore by definition a lower risk category, the associated insurance premiums should be lower as a case of that. So that's one way you can look at it. There are two other elements: response and recovery, and sometimes these aren't often understood. Response is about minimizing scope and scale. How can we? It might be on the yacht now, but what else is attached to the yacht? It could be other yachts that you're in contact with. It could be an owner's businesses. It could be the family networks. It could be your suppliers. It could be your management companies. It could be a law firm. It could be an insurance firm. Who are connected and what could this particular attack, whatever it looks like, whatever it is, be designed to do? Because as we've talked about before, you could be on the super yacht, but you may not be the main focus of the attack. The end goal might be something differently entirely, which may not be realized until months and months further down the line. So response is about minimizing scope and scale. Recovery then comes into, well, how do we go back to business as usual as quickly as possible? How do we learn from what's happened and how can we make sure that our brand and our reputation is preserved? And how can we then make sure we put in perhaps the resilience that we need to make sure that this doesn't happen again? So, there are lots of facets to this. Governance is key. Looking after your people is key. Putting in the right technical control measures is key. Ensuring yourself is important. And then when you've got plans, rehearse them. Because you don't want to be dusting them off and saying, how does this work when things are going wrong? You want to be able to have a look at them and say, I know exactly what to do. If there's a fire on board, the crew know what to do. What happens if the navigational system shuts down? What happens if the propulsion system shuts down? Who do they call? What do they do? So those are some of the things they should perhaps think about investing in and looking in at the moment.
All right. Well, I think we're going to leave it there. Thank you very much. Thank you, Jeff, and thank you, Mike.
Pleasure.
Appreciate your time. We're going to take a break, and then we will be back with Act 7 of As the Prop Turns and our final segment of Yacht Sales and the Law. Thank you.
Thank you. Thank you.
Thank you very much.
IYBA would like to thank Yacht World for their support of this year's 25th Annual Yacht Sales and the Law.
What the hell has Chad got to say now? Sven can't run the boat. Well, I'm a broker now. I fix problems. We gonna get Frank to run. Heck, he knows the boat. Problem solved.
A huge blaze in Fort Lauderdale ruined two multi-million-dollar yachts. The blaze started early in the morning, and firefighters they were on the scene for a large part of the day just trying to get this thing under control. Local 10 News reporter Roy Ramos live in Fort Lauderdale with the story.
Bill Boatwise. What? You gotta be kidding me. It sank? No, like it's literally like at the bottom of the river. It literally sank, and there was an explosion as well. Come on. He's suing everybody, including me? Frank's in jail? I don't understand. This is a complete and utter disaster. You gotta be kidding me. The black water tank exploded, and there's fecal matter everywhere. This is horrifying. This is horrifying. This is not good. This is not good. Yeah, I have no idea what we're gonna do. I didn't think that fiberglass could burn that quickly. It can. Okay, yeah, all right, I guess I'll wait to hear from somebody. Yeah, hopefully it's not the FBI. I mean, they've only been here once. Wow, this is fun. I'm enjoying myself. Be a yacht broker, they said. It'd be a good time. Yeah, meet new people. Go to interesting places.
Welcome back for the final segment of Yacht Sales and the Law. We just watched Act 7 of As the Prop Turns. I'm here again with Jeff Cox, maritime lawyer at Cox & Company. We are going to discuss some of the issues that were raised in Act 7. But one thing I want to talk about at the beginning, which really set this whole chain of events in motion, was the fact that the buyer's captain was unable to enter the U.S. on his visa. In an earlier segment, we talked about how, historically, foreign crew were unable to work on U.S. documented vessels because they couldn't get a B-1 visa. And although there's been a recent change to immigration regulations that allows certain foreign crew to get a B-1 visa, they have to be able to show that the boat they're going to be working on, will be in both U.S. waters and outside the U.S. in foreign waters. And in this case, the buyer's captain didn't have that documentation. Now, when CBP issues some more formal guidance on this in the next few months, we expect there to be like a letter or a form that these foreign crew can carry with them to show the CBP officer explaining the visa category that they're using, and there will be some guidance about the kind of documentation that they need to provide to show that they're going to be working outside the U.S. Right. But moving from that into the issue that it caused, which was having to hire the seller's captain to move the boat, and then obviously what resulted from that. What kind of liability do you think the buyer is looking at in this situation?
Well, the buyer's going to have a problem with his insurance company at the outset. The insurance company likely required him to have a pre-approved captain running the boat only. And it wasn't clear to me from the facts that this captain ever was approved by the insurance company. So at the outset, the insurance company is going to be looking at denying the claim entirely. And they probably would get away with doing that because they didn't sign up for the risk of having unknown captains driving this boat. They signed up for a known risk of this captain with this resume running the boat. That's what they signed up for. That's the contract they made with the buyer. So they're not going to be bound to pay any losses. There may be some argument that these losses weren't caused by the fact that there was an unapproved captain, but the contract was breached, and insurance contracts carry with them a duty of utmost fidelity. And it's likely that the buyer won't be able to show that they had incredible utmost fidelity to their insurance company by putting a different captain on the boat. So it's, not knowing full investigation of what's happening here, I would expect that there will be no insurance payout on this set of facts.
And that would apply to both the casualty, the loss of the vessel.
The insurance company is just they're not going to be a party to it.
Right.
They didn't sign up for this.
But it would also apply to any liability for damage caused to third parties.
Exactly. And that liability will come back to the buyer. The vessel could be sued in rem for the damage that it did to the dock as a maritime elision, and the owner will be liable for that too. The owner would have some possible defenses that we may talk about later, but I would expect if I'm the owner that I am not getting my insurance proceeds and I'm probably rebuilding this dock and whatever else may have happened.
And what about the seller? Do you think the fact that it's the seller's captain creates any liability for the seller?
I would expect that if enough money is at stake, that there will be lawyers who will try to thread the needle and say something to the effect of, this captain was your employee and you allowed your employee to go run this boat, and your employee, it's not clear to me how the captain may or may not have caused this, but I would expect that the actions will be brought, and you'll be put to the test of whether or not you can defend against that. I mean, it's a stretch, but if there's enough money there, and if I would say that there's enough to get to discovery, so you can anticipate that you're going to be in that litigation, you're going to be responding to it. You may prevail, but I would expect that you're going to be in that litigation.
I had a client, this has happened a couple times actually, where the buyer asked the seller's captain to relocate the vessel after closing. Mm-hmm. The seller was going to continue employing the captain on his next vessel. So he was an employee throughout this period, and both times I asked them to sign a letter agreement saying that the captain's working for us. He's not the seller's employee when he's moving the boat from A to B. Just to head off that's sort of an action.
Yeah, I'm aware of a situation where, fortunately, it wasn't directly one of my clients that this happened to, but there's a custom sportfish builder up in the Carolinas who sent a member of the family on a prolonged delivery to the new owner of this custom sport fishing boat. And this member of the family was also a boat captain and was, I believe, running the boat early in the morning before the sun came up when the boat struck the reef down in Puerto Rico. And some people watching this may know what I'm talking about now. It's sort of a known thing in the industry, but my understanding is that litigation is still going on, and it's been about 3 years. So yeah, sign the letter aggrement.
Yeah, it's always better to protect yourself with a piece of paper.
Better to be prepared than disappointed. I mean, it's easy enough to with a brief letter agreement to just cut it off, and a lawyer who was looking at it would just say, "Nah, there's nothing here. This is not a door we can walk through." But without that, if there's deep pockets, they're going to try to find a way.
Now, you mentioned defenses that the buyer might have. Under certain circumstances, a buyer is entitled to limit his liability Can you tell us a little more about that?
Sure. In maritime law, there's a concept which is an old ancient concept, and it's a concept that's foreign to many non-maritime lawyers and frankly, most of the world. And that is that if you are a vessel owner and you have a ship or a yacht and it's on the, out on the sea and something happens, something bad, your financial exposure is limited to the value of the boat. It's the reason for it is without it, you wouldn't have shipping. You couldn't have people buying ships and having them going on the high seas, way out of their reach and control, and have something happen where the owner of the vessel had nothing to do with it, no privity, and the owner of the vessel could theoretically have all of their wealth exposed. There would be no shipping. There would be no international commerce. So over the course of history, this international maritime law concept of limitation of liability has arisen, and it's a real thing, and some people are shocked by it. But the policy of it is necessary in order to have international commerce. You simply can't ship everything back and forth between nations to have international trade and have the people who own the boats have their financial fortunes at risk. So it's a necessary concept, but there it is.
And when you say limited to the value of the vessel, it's the post-casualty value of the vessel.
Yeah.
If the boat's on the bottom,
if the boat's at the bottom,
it could be zero.
It could be negative. It costs money to get it. Yeah.
So if, let's say, the dock owner in this case wanted to sue the owner, the owner of the yacht, that is, for the damage caused to the dock,
right?
The owner could assert limitation.
He may well,
and potentially avoid liability to the dock owner.
Exactly.
And there are exceptions to limitation. You mentioned if the owner has privity and knowledge,
right?
But in this case, if it was just the negligence of the operator,
right,
it's possible he would be able to limit.
It's possible, yep.
Now he'd have certain other responsibilities. I mean, he'd be responsible for wreck removal.
Yes.
And he may or may not have insurance for that.
Right, and that could be a big deal.
And that's actually become more of an issue in.
Yeah, that's salt on the wound.
Yeah, under state law, that's becoming. There've been a number of issues with abandoned vessels and municipalities that have to spend money to raise them and remove them.
Oh, years ago, when I was at your firm, it was a period of multiple hurricanes, and there was wrecks all over the intercoastal, and we were dealing with it constantly. And it turns out there's probably about 17 different agencies that are all going like this, trying to say who's responsible for getting this out of here. Is it the Coast Guard? Is it the Army Corps of Engineers? Is it the Fish and Wildlife? I mean, whose issue is it if there's a sunk boat out in the middle of the intercoastal? And that was something that we were dealing with, pretty regularly with all the hurricanes that we had in the early 2000s. So that's a big deal.
And in the end, I mean, whoever pays to remove it, the owner's going to be on the hook.
Right. Yeah, because they're going to go back to the owner and try to get paid.
Now, sort of expanding from the particular fact pattern that we've been talking about, what other sorts of liabilities have you seen that arise post-closing or that give rise to litigation between buyer and seller after closing?
Well, I mean, there may be a claim of negligence for the referral of the captain. There may be a claim of negligence for not acknowledging that it's unlikely that this captain would be insurable on the boat without at least giving a resume and an opportunity for the underwriter to give a thumbs up or a thumbs down. So I would be a little bit concerned about who made the recommendation. And I would counsel anybody thinking of doing that just assume that somebody needs to be approved in writing with a resume by the insurance underwriter. Just assume it. Nobody's going to be mad at you for trying to get somebody approved if the insurance company didn't care. And I can't imagine a scenario where they wouldn't care, because the insurance company is signing up for a discrete risk. And the risk is this captain and that boat. And the insurance company has the opportunity to evaluate that captain's credentials and make a determination if they want to underwrite that risk. And if the boat owner varies that deal even a little bit, the insurance company can exit the whole scenario and just avoid coverage.
Yeah, that was something we were talking about earlier in the context of surveys. And sometimes people want to withhold a survey from an insurer because they're afraid there's something in there that would cause them concern. But that's the last thing you want to do.
No, that's the last thing you want to do.
Anytime you fail to disclose something to an insurer, you're giving them a reason to deny the claim.
That's absolutely right. Underlying concept in insurance law is the concept that there's a Latin term for it, which I'll butcher, uberi fideli or something along those lines. Utmost fidelity. You have to be completely forthright to your insurance company. And if you're not, that will give them a reason to avoid coverage, which means that you'd have then been sending premiums to them for no reason because you have no insurance. So yeah, you have to be totally forthright to a fault. And if you think you're going to avoid, put it this way, why would an insurance company not want to insure a boat as a result of something on a survey? They wouldn't want to insure a boat as a result of something on a survey because that something on the survey increases their risk. And they'll insure it for a proper premium, but their premium is calculated based on what they know to be the risks. And if you avoid giving that information to them, it's completely unreasonable to expect them to pay, actually. So that's they're going to demand a survey. I can't think of a deal where the insurance company has said, fine, we'll just insure the boat, no survey required. I can't think of a time. And it shouldn't happen that way because the insurance company won't be in business for long if they do that. So
I've seen a few other things that have happened post-closing that have sort of arisen in the context of a deal. For example, I had a client who was involved in a situation where a buyer said there was something wrong with the vessel's engines. And normally you take a boat as is.
Right.
There's a complete disclaimer of warranty. In this case, he had done an engine survey, but he said that somehow they had doctored the oil samples or something. Basically, he was trying to get around the contract and get to fraudulent inducement. And you try and do everything you can within the four corners of the contract, but there's other causes of action.
Yeah, you get outside of contract law into tort and things like that, and that sounds like what they were trying to do because they were going to lose in contract. The contract law is what it is. It's this is the sale of goods governed by the Uniform Commercial Code, and if you're within the four corners of the contract, if you've hired a surveyor and you've accepted the boat, accepted the engines, that's it. Too bad, so sad, right? But to get outside of the contract into tort remedies, that's a fact-dependent analysis that it would be an uphill climb. But if you had, facts are stubborn, right? If you have them and you can show that they did doctor, there wasn't the oil from that engine or something like that. You can imagine we've seen worse things these days. But if that was true, then what's in the contract is really not the issue. The issue now is tort law. Did you have a duty to give me an accurate oil analysis of the oil in this engine, and did you breach that duty? And was I damaged by that breach of the duty? So that's really outside of the contract and very difficult. You can't contract around it, frankly. So it is what it is.
One thing, you mentioned that these are all governed by the UCC. I think for a lot of non-lawyers, they look at sales of vessels and sort of admiralty generally, and there's a certain amount of mystery around it. You think that there's a different set of rules that apply. You're in admiralty jurisdiction. They don't realize that the sale of a vessel isn't in admiralty jurisdiction.
Right, exactly.
And it's just like any other sale of goods under state law.
Absolutely.
All warranty law, everything else that applies.
No, the issue isn't, there's no, a contract for the sale and purchase of a vessel or the construction of the sale and purchase of a vessel is a dry land contract governed by the Uniform Commercial Code of the United States. The problem for guys like us is to know the boundary of where maritime law issues start and where they stop. It's not so much a maritime issue with yacht purchases, but it's all the ancillary stuff that comes with it, the hiring of captains and crews and chartering and things like that. Those are all maritime issues.
Maritime liens.
Yes, all that stuff, which is inverted for non-maritime folks in terms of first in time, first in right kind of stuff, last in time, last in right, compared to real estate deals and things like that. The other area that I've seen some confusion, obfuscation, is with respect to mandatory or contractual obligations to disclose material defects and things like that. People put that in contracts, and if you want to sign and agree to that, fine, go for it. But there's not something that's inherent in the sale of goods that says that you have to do that. This is not a real estate deal. It's a sale of goods. It's a widget, a complicated, big, expensive widget, but it's a widget. And we see that sometimes, and that's it certainly opens doors to people who are looking for a cause of action, which I think is where that's headed and why it's in those contracts.
I see it, even in the EBA listing agreement, there's a set of reps and warranties about the condition of the vessel. And when I'm representing an owner, I just delete those.
I do too. It's gone.
Yeah.
It's the first thing, it's gone.
We're not making any warranty as to condition. The buyer has to rely on a survey.
Do you want to be in court and you want to go buy another boat?
Right.
Because if you make those warranties and representations, all you have to do is give the other side a colorable claim to get past the motion to dismiss, and now you're in discovery, which is the worst part of litigation, because now you have to respond and you have to produce and everything else. It's got to go. It's got to be out of the contract. So we take it out too, 100%.
Now the converse of that is making sure buyers understand that they're really relying on their surveyor.
Yes.
That they're not going to have a remedy if after the sale closes they discover something.
Right.
So they have to be really, confident.
Right, and the surveyor, of course, has a disclaimer at the end of it.
Right.
Says that anything that I didn't find, it's not my fault because I didn't tear the boat apart, because there's a limit as to how far an inspection can go. But it's one of those things where does the law follow business or does the business follow the law, right? We need to survey boats, and I think everybody's doing the best they can with that.
Another thing, we mentioned earlier, but it can be a problem post-closing, is when you do have liens that pop up. Because, in maritime law, obviously liens don't have to be recorded.
Right.
So how do you protect a buyer?
So we use, in situations where a buyer is an entity and a seller is an entity, we use a warranty of title, which basically brings in the protections that the bill of sale would have had if you were dealing with an individual. And we do that because the entity could be wound up or dissolved shortly after closing, and all of your representations and warranties that are found on the bill of sale would now be for nothing because that entity no longer exists. So what we do with the warranty of title is we transfer those representations and warranties to what I would call a solvent defendant, which is your seller, who presumably is a guy who, if you had to sue, you could collect from. And frankly, that's as good as you can get with a boat deal, because there are maritime liens that could arise. You could have put fuel in the boat the day before closing and not paid the bill. The marina with the fuel dock has a lien now, unrecorded, undiscoverable. But if they show up a week after closing and say, "Excuse me, we're owed X dollars, we never got paid," the new owner of the boat has that, because, as they say, a yacht or a ship attracts liability like barnacles. So it's certainly a risk, but in reality, it doesn't come up that often. I've been doing it for a long time. It doesn't come up. It's a theoretical risk that we have to address, but there's a few protections, like the warranty of title we have. There's an equitable doctrine of latches, which is if you sit on your rights for too long, you're not going to go into a court and find some judge to say, "Yeah, I know you bought this boat 3 years ago, and you just couldn't get around to bringing this action, but now we're going to allow you to use the courts to dig this up and beat the guy over the head with it 3 years later." The court's likely to tell you to get out of the court, and so there's that. That's an equitable doctrine, and other things that you can do. You got your warranty of title. We use crew releases. Mm-hmm. Difficult to say how enforceable they would be. Most of the cases that you'll read would say almost never.
Yeah, their wages are sacred.
Yeah, and a seaman is a ward of the court.
Right.
And you could have them swear up and down 15 different ways that they've been paid, they're not owed anything, and then 2 weeks after closing, they could say, "Oh, by the way, I was owed, 10 days of vacation time that I forgot about when I signed that release, and now I claim I have a lien against the boat, and I'm going to have it arrested and everything else." So there's that. But another thing that actually acts to protect against unknown liens is quite simply the cost of arresting a boat to enforce a maritime lien. $30,000 maybe out of the gate as a ballpark figure to hire a lawyer, get the marshals involved, file the action, probably 30 grand before you even start. So it better be worth it. So a lot of claims that are less than that, they're not enforced.
Yeah, although on a documented vessel, it's relatively easy to record a notice of a claim of lien, and then if that happens close to a sale, they have some leverage.
Now they got leverage, exactly.
Yeah,
exactly. Which and that's only, as far as I know, it's only U.S. Coast Guard documented vessels that have that facility. You could file a notice of claim of lien, saying, "Attention, anybody who pulled an abstract on this boat. This guy owes me money and he hasn't paid me." That doesn't help you sell a boat. Because now everybody's got their radar turned on. It's like, why is there a captain that's claiming he hasn't been paid on this boat that I'm thinking about having my buyer sell?
And there's no sort of process to establish the validity of the claim. They just have to, it's just a notice.
They just send it in. It's simply you write it and send it in and they record it. Now, there may be some mechanism to have it removed or to show cause or something like that, but I've never had to deal with it because it's just one of those things that you don't let happen. With a US flag boat, you make sure you pay your bills because somebody could just in half of an hour send this thing and it'll be recorded against your document on your boat and it'll be seen by the next person that wants to buy your boat because they're going to pull an abstract. So it's right there.
Now, going back to the warranty of title, which is the primary defense against maritime liens and other defects in title post-closing, we've gotten pushback sometimes either from people who, just as a matter of personal policy, don't give out personal guarantees, are sort of very averse to it.
Yep.
And then also more recently in Europe, we've seen lawyers who are pushing more and more to limit the personal guarantee or warranty of title, either to a certain amount or to a certain duration or both.
Yeah. Well, you got to push back because first of all, you should establish your right to have the warranty of title in a document list with your first offer. We're going to offer this for your boat. These are the documents you're going to provide, and one of them is going to be a warranty of title from the beneficial owner. When they want to sell their boat, they'll agree to that. But when they get to closing, they may push back on it because somebody will say, "Oh, geez, this guy just doesn't sign those things." It's his policy.
Sometimes it's just a matter of explaining to them that this is a warranty only as to title. This has nothing to do with condition or anything else. You're just saying.
The word warranty means different things. Right. Yeah, that's true. I will say that I've also had situations where people tried to resist signing a warranty of title, but I'll tell you that they've never succeeded because at the end of the day, I'm not going to let my client buy the boat without it. If it's in the dock list, it's the seller's in breach.
Right.
So if you don't sign it, you're in breach.
Right.
We're not closing. You want to sell your boat or not? The dock list, and this, like you said, maybe on international deals where they see the word warranty of title and they're like, maybe I don't want to do that. Or somebody might say, this entity that owns the boat shouldn't have to sign a warranty of title because it won't be dissolved and all this other stuff.
Right.
Well, if you tell me that you're not willing to sign a warranty of title, immediately I'm concerned that there's problems with the title. It's one of those things that if you protest too much, you've only exacerbated my suspicions. And now I think that there's a reason why you won't sign it, because if the title of the boat was clean and you had no skeletons in your closet or anything to be concerned with, you should have no resistance to sign it. It's kind of like, there's nothing wrong here, there's nothing to see, but don't investigate. So it's tough. And that's probably why I've never, ever closed a deal without one if there was entities involved. With individuals, the bill of sale covers it, really.
Right.
Maybe we do add a little more protection, but the bill of sale really covers it. As real of a risk as it can be and as real dollars as it can be, in actual practice, it doesn't come up that often. 1 out of 100 deals, you hear somebody squeal about it, and that's about it.
A few times I've had people who resisted a personal guarantee, were willing to give a guarantee from another entity that they could show was, capitalized, but even then, you could pull it out after closing.
The problem is that it's in the form of an affidavit, and if you move to another entity, the question is, does that entity have basis for knowledge that they're swearing to? So you get into that issue too. It's got to be from the
guy, from an individual.
Yeah, the rich guy you're buying the boat from.
Yeah.
He's the guy who would know. He's the guy who would know, did the last captain get paid or did he leave in a huff and not get paid? He's the guy who would, that's, a lot of the things that could theoretically give rise to a lien are sloppiness, unpaid crew, dockage bills slip through the cracks. The other stuff is getting into like wholesale fraud, like mortgage and something like that got slipped in. I mean, that's a different story,
right?
If you got somebody who's going to those lengths, that's another story altogether,
right?
But the stuff that we might see on the edges would be like the repair bill from Rybovich that didn't get paid in time or whatever, But
and usually you don't even have to resort to the warranty of title. Somebody will just pay that.
No, somebody will pick up a phone call and say, "Hey, we're closing on this deal. Let's get this guy paid." Or you might pick up the phone and say, "Hey, you've been paid," or just whatever you can do. And it works out in practice a lot easier than it may appear to, when you look at, particularly if you're not a maritime attorney, you look at these laws, you're like, oh my God, how could you possibly ever even close a deal? It works out.
Well, it's tough because, aside from getting, letters from the captain or the manager, or people saying that all the bills have been paid, there's no way really to do due diligence. You can't go and call every marina the boat's been in.
You couldn't know.
Yeah.
We can track the AIS backwards, through history.
No one does that.
No.
Yeah.
It would cost a fortune. I mean, we'd have to hire consulting teams to go out and track it down, and it would.
And even then, you could have missed something.
And the juice wouldn't be worth the squeeze.
Yeah.
Because ultimately, if you have a solvent defendant that you're buying the boat from, and something comes up, you make a phone call and say, hey, guess what? Somebody is saying that they weren't paid, and we have this warranty of title that you signed 3 months ago. Here's the wiring instructions, and here's the invoice, and that's probably the end of the story. The guy's going to pay it, because you got him dead to rights.
Mm-hmm.
It's just like, why would you want to even expose yourself to the hassle of what your next 2 years of your life will look like? Nobody wants to deal with it, so they pay it.
Well, are there any other sort of post-closing issues that you can think of?
Every deal is different, Every time you close a deal, there's different post-closing issues that come up. A lot of them have to do with what does the new owner do next? Is he going to be going into the shipyard and getting a refit? Or is he hiring a new set of crew? Is he keeping the crew that have been there? Sometimes after closing, they'll turn around and put a mortgage on the boat. And, sometimes they do that during the closing, but sometimes after. It's as your father put it, a three-dimensional chess game with changing rules. So it's it goes on and on and on. It all depends on the situation, and when you think you've seen it all, just give it a week. There's something else coming. So.
Well, I think that's a good note to end it on. Paul, I think that's all we got.
David, thank you so much. I think you did a masterful job of moderating all of our panel discussions over the course of the last 2 days. There's no doubt that Bill Boatwise and Bubba Calhoun provided some interesting opportunities for learning. We got the opportunity or the chance to follow a deal from a somewhat normal beginning to a calamitous and explosive end, let's say. I think we had great expertise in all of our panels. Tell me, how was your feel for the educational value of the 2 days?
I think it went very well. I think the story provided a great framework to explore some of the issues around yacht sales and the law. I think we were able to talk about everything from customs duty, listing agreements, conditional acceptance, insurance, force majeure, arbitration, all the way through to post-closing liabilities. I think it was a really great vehicle for exploring these issues, and I certainly learned a lot about some issues that aren't necessarily at the center of my practice but come up often enough that it's helpful. So I'm really glad that I got to do this, and thank you for the opportunity.
Well, thank you for doing it, and I think the audience at large has once again come to recognize the value of bringing a lawyer into the deal. Head off the problems at the pass, or when they do occur, you've got the right people to go to give you good advice. This event was originated 25 years ago. Bob Zarkin, as a member of the IYBA Board of Directors, at that time was the FYBA, the Florida Yacht Brokers Association. And our first event was held at the Northern Trust Building in Miami. Rob Moss, your dad, has been a supporter of this event from the beginning. And we're very, very thankful to him and to Allie Moss Rogers Lindsay for the support they've lent us over the years. This year we had Lauderdale Marine Center, we had Yacht World, Howard S. Reeder Incorporated, Customs Brokers, and we also had the assistance of JV Connectivity, bringing us connectivity throughout our remote segments. Pier 66 provided us a wonderful venue to bring forward this year's version of Yacht Sales and the Law 2020. Come back again next year for 26th Annual Yacht Sales and the Law.
This 25th Annual Yacht Sales and the Law has been brought to you by Allie Moss Rogers and Lindsay, PA, Yacht World, Lauderdale Marine Center, Howard S. Reeder Incorporated. Our internet connection has been provided by JV Connectivity. And our generous hosts for panelists and production team were Pier 66 Marina. We'll see you next year.
Shake your boots, put on your dancing moves.